A surrogacy arrangement involves a situation where another woman, known as a surrogate, carries and gives birth to a baby for a couple who want to have a child. Surrogacy is legal in the UK, however the law outlaws commercially arranged surrogacy and advertising for surrogates, so finding a surrogate can be challenging. Surrogacy contracts are unenforceable in the UK, which means that everyone relies on each other to honour the agreement, both in respect of handing over the child and paying expenses and dealing with any other issues. For heterosexual couples and male couples, there are two types of surrogacy. One is gestational surrogacy. If you have embryos in storage or are able to create embryos through IVF treatment, they can be transferred to a surrogate who then carries a child she is not biologically related to. Traditional surrogacy involves a situation where your surrogate donates her egg to you as well as carrying your child. Again, conception occurs through IVF treatment or artificial insemination at a clinic. In practice, surrogacy is more unusual for female couples. Since your surrogate will be your child's legal mother, you will need to make sure you can secure your position as legal parents when your child is born. You will only be able to apply for a parental order to become the child's legal parents if one of you has provided the eggs. If neither of you is your child's biological parent, then surrogacy will be much more complicated and will need very careful planning, so please take advice. The legal position under UK law is that the woman who gives birth, the surrogate, is the legal mother of the child. If the surrogate is married when she conceives, her husband is the legal father, unless it is shown that he didn't consent to the conception. The same rule makes the surrogate's wife or civil partner the other legal parent if she is in a same-sex relationship. If the surrogate is unmarried, in most cases the intended father will be the legal father, assuming that he is also the biological father. The intended parents have no legal status in relation to the child unless they apply for a parental order. The UK legal solution for resolving parenthood issues in surrogacy cases is a parental order. This is a court order which makes the intended parents the legal parents of the child and permanently extinguishes the parenthood of the surrogate and her spouse. Once a parental order is made, the birth will be re-registered to record both intended parents as the legal parents, and a new birth certificate will be issued. To obtain a parental order, the intended parents must satisfy the family court that the order is in their child's best interests and that they meet all the relevant criteria, which are: first of all, the conception must have taken place by embryo transfer or artificial insemination, and the child must have been carried by a surrogate. Also, one or both of the intended parents must be the child's biological parent. The intended parents must be married, or civil partners, or living together as partners in an enduring family relationship. Interestingly, the government has told Parliament that it will be changing the law during 2017 to enable single parents to apply too. And the intended parents must make the application to the court within the 6 months after the child is born, although in exceptional cases the court can extend this. First of all, the conception must have taken place by embryo transfer or artificial insemination, and the child must have been carried by a surrogate. Also, one or both of the intended parents must be the child's biological parent. The intended parents must be married, or civil partners, or living together as partners in an enduring family relationship. Interestingly, the government has told Parliament that it will be changing the law during 2017 to enable single parents to apply too. And the intended parents must make the application to the court within the 6 months after the child is born, although in exceptional cases the court can extend this. And at the date they apply and the date the order is made, the child must have his or her home with the intended parents. Also, at the date they apply and the date of the order, one or both of the intended parents must be domiciled in a part of the United Kingdom. The intended parents must also be both over the age of 18 when the order is made. And the surrogate and her spouse must consent to the order, that is, unless they can't be found or are incapable of giving consent. And the surrogate cannot validly consent until the child is at least 6 weeks old. And importantly, no more than reasonable expenses must have been paid, or the court must agree to authorise the payments retrospectively. That sounds complicated, but the procedure is relatively straightforward. Intended parents apply for a parental order by completing a simple court form called a C51. The court then appoints a parental order reporter from an organisation called CAFCAS. He or she will meet with the intended parents and, if possible, if she is based in the UK, the surrogate and her partner. The reporter then writes a report for the court, making a recommendation about whether a parental order should be made. Straightforward UK surrogacy cases are dealt with at the junior level of the family court. There will normally be 1 or 2 informal court hearings, and typically little information and evidence is required. If there are any complicating or international issues, the application will be heard by a High Court judge. The procedure in the High Court is significantly more formal, and extensive evidence and legal argument is usually required. There are some special considerations in international surrogacy cases which you need to think carefully about and take advice on. Think about how things work in the destination country. Is surrogacy legal? And what regulation is there, if any, of the services you plan to use? And are those services well established? Are they safe and ethically run? And have you budgeted accurately? Also, if you're crossing international borders, what nationality status will your child have, and how long will it take to get the documentation you need to travel home? Think about parentage. Will you be recognised as the legal parents of your child everywhere you need to be? And what processes do you need to follow to secure your parentage? UK law treats your surrogate and her spouse as your child's legal parents, even if you are the legal parents in the country where your child is born. Parents who want to secure their status in the UK need to apply for a parental order after the birth. The application will be heard before a specialist judge in the High Court, who will be careful to ensure that a foreign surrogate understands any documents she is asked to sign and that the formalities have been properly complied with. They will also look carefully at any payments, as most international surrogacy cases involve payments of more than just expenses to the surrogate and to any agency. Since UK law expects parents to pay no more than reasonable expenses, the court must agree to authorise any payments before it can make a parental order. The court has said it would not refuse an order which was in the child's best interests unless the case was one of the clearest cases of abuse of public policy. However, the court makes each decision on a case-by-case basis. The court will also consider domicile issues. One or both of the applicants for a parental order must be domiciled in a part of the United Kingdom, Channel Islands or the Isle of Man. In surrogacy cases, it's essential to take specialist advice before you embark on anything. The reality is that there are more surrogacy arrangements than parental orders. This means that there are children growing up with no legal relationships to their parents, which leaves them in a difficult and vulnerable position, which can easily be remedied.